Hi everyone, we're just going to give everyone 30 seconds or so to join before we kick off today's webinar. Okay, it's 1 minute past 11, so I think we'll get started as everyone else continues to join. So hello everyone and welcome to today's SEND National Trial webinar for parent carers. My name's Holly Stallard and I work for Mott MacDonald, and I'm delivering the webinar for you today on behalf of the DFE with my colleague Emma Bird, who's also on the call. So before we go through the agenda and introduce all our presenters, I just want to inform you all of a few IT housekeeping rules and some Teams etiquette for the webinar today. So I first want to mention that today's webinar is being recorded and it will be uploaded to our SEND online toolkit. So for the duration of the webinar, please can we ask you to keep yourself muted and also to turn your videos off. Presenters will have their videos on whilst they're speaking their sessions, so we just want to make it super clear for everyone who's presenting. So yeah, if you could keep your videos off and your cameras muted, that would be brilliant. And if you are unfamiliar with Teams, then you can see the icons here on the screen and they will show you how to do both of that. So if you are struggling with Wi-Fi connection today, as we know it's all been an issue for everyone, we would suggest you turn off your incoming video and you can follow the instruction on the slide just there. So clicking the 3 dots and then clicking the drop down that says turn off incoming video, and that will just limit the bandwidth going wrong. So the panel Q&A at the end of the webinar today will be going through all questions that are posted in the chat box. So we won't be taking any verbal questions in today's webinar. My colleague Emma will be managing these questions, and we're going to prioritise the questions by number of likes that a question has. So if you do want to like a question, then just hover over the box and give it a thumbs up, and we'll prioritise the ones that have the most thumbs up. If you don't have the chat option and would like to ask questions or see the questions being asked, this may be because you've joined as a guest. So we would encourage you to leave the call and log into your Teams account and rejoin. So just a quick bit of Teams etiquette for everyone. So please do participate in the Q&A. We've got some fantastic speakers on our webinar today. So do make the most of their wealth of knowledge on the national trial. Secondly, if you do have multiple questions, just for ease of Emma's sake, please do type 1 question per message, as this will make it easier to prioritise the questions. Thirdly, as I mentioned, please like other people's questions. So if you would like it answered, just to give Emma an idea of how to prioritise, please do give it a thumbs up. And also please be aware of duplicating questions. So just to limit the amount of traffic we get in, make sure you check if your question's been asked already. So we're going to move on to the agenda now. So as I mentioned, we've got some fantastic speakers with us today to share their knowledge and experience with you all. So I gave you a quick introduction to myself and my colleague Emma. So next I'm going to pass on to Tina Emery, who's the co-chair of NMPCF, to introduce herself. It's then going to be passed on to the DFE lead SEND advisor, Andre Imich, who will give everyone an overview of the SEND national trial. Move on to a session media. Susanna and Audrey will be doing this session. And we also have the pleasure of welcoming a parent carer today, Lois Mansfield, who is going to share her experience of using mediation. We're then going to hand over to Jason Greenwood for a session to run you through what to expect at a hearing. And lastly, we'll be ending the webinar with a panel Q&A session where all of you as attendees will have the opportunity to ask all of our knowledgeable presenters any questions you may have about the topics we've covered today. So without further ado, I'll hand you over to Tina from NMPCF. Thanks, Tina.
Thanks, Holly. Good morning, everybody. My name is Tina Emery. I'm one of the co-chairs of the National Network of Parent Carer Forums. And I'm, as a parent, carer myself, the decision to go to tribunal is never an easy one. So I'm grateful for Mott MacDonald for this webinar to inform those that are thinking of embarking on the tribunal system. I'd like to introduce Andre Imick, the professional advisor at the Department for Education. Andre.
Thank you, Tina. It's lovely to be here, and it's great that so many parents have joined today to find out a lot more about the SEND national trial. As Tina just said, the decision to appeal to the tribunal is never an easy one. We know that it involves a lot of time for those who make that decision to make the appeal, and it involves a lot of work, and it can involve quite a lot of stress. So we need to make sure that people understand the system that they're about to enter when they make that decision to make an appeal. In actual terms, the number of appeals to the tribunal is going up every year, but relative to the number of decisions that local authorities make every year, it's still a very, very small percentage of that. Local authorities are making something like over 400,000 decisions a year on EHC plans and requests for those, and the number of appeals is relatively small. We would say it's still far too many because each one brings all sorts of demands. But nevertheless, where local authorities and families are able to communicate well, where there's good casework going on, where there's co-production well embedded, where there are good advice and support services such as the SEND service, and of course where the local area has got a good range of provision available for different types of need, the need to go to an appeal, which is never an easy one, should be minimized. And we do see different rates of appeals from different local areas. And so I'm sure there are lessons there for all of us. But what I want to do now is to take us through the national trial. What does that take? What's that about? And what does it involve? What can it do? What can't it do? And the single route of redress national trial. Before the trial, as far as education, health and care plans were concerned, the tribunal was only able to be interested in the education aspects. If families were unhappy about health and social care, there were different routes of redress and complaint to follow for that. What we now have is a system where if a family does have concerns, parents or a young person, about the wider elements, you can appeal to the tribunal about the health and social care aspects, needs and provision. Health needs, social care needs, health provision, social care provision. And where an appeal comes through on that front, the tribunal has the power to make non-binding recommendations. I'll come back to that phrase, non-binding recommendations. The trial was introduced only for 2 years initially, but it has been extended for a further period up to the end of August next year. That's in part because of COVID. Next slide. So what were the key aims? What were we trying to do when we introduced the trial? Well, we wanted to create, sort of take further that vision from the reforms about a much more holistic, more person-centered view of the child. So the fact that you could go to the tribunal and they could only take a look at the education section suggested that the tribunal itself wasn't able to take that more holistic person-centered view. And we wanted to make sure that it was all working in tandem with the overall aspirations of the reforms. So it's bringing that in, brings it in play with every other part of the education, health and care plan, the joined up needs and provision sections. We also think that it will help improve local area functioning. So better joint work between health, social care and education. The other aim of a trial, remember the word trial, we're testing something out, is to explore whether this extended right is something that should become a permanent part of the legislation. Should it be there as a permanent feature? Next slide. So what are the key features of the national trial? Well, again, The tribunal now has wider powers. It can consider and make non-binding recommendations about health and social care. It applies to all local authorities and CCGs. And when I say local authorities, a local authority is responsible for both the special education elements and for social care. So a local authority covers both angles. There also needs to be a, there also, to make an appeal to the tribunal for the extended rights, it has to be an appeal that has an element of education about it. So you can't just appeal about health or social care elements of a plan. The appeal must include something about education, so something about the placement or the special educational needs, section B, or section F, the special educational provision. And whilst an appeal to the tribunal for the extended rights is going on, families can still continue to make complaints through other sources. So that's next slide. Recommendations are non-binding, so there isn't a legal duty on health or social care team in a local authority to follow the recommendations. But they are generally expected to be followed. And if they're not, families can complain to the Ombudsman or seek to have the decision judicially reviewed if it isn't followed. Now, the expectation is that the experts involved in a tribunal hearing or a tribunal judgment would expect the decisions to, or their recommendations to be followed. And I think that that's what an ombudsman or a judicial review might feel. We don't think that's been tested, but it is fairly evident. We've also asked Ofsted and CQC to incorporate intelligence about appeals on the trial within the local area inspections. So that's part of their evidence about the effectiveness of the local area. We've also commissioned an independent evaluation. It's critical we get good understanding and good evidence about how the trial is working. What are the implementation processes? How are they working? Are they well set up? What are the perceived outcomes on both families? What does it mean for families? Where does it lead families? And what's the impact on agencies? What's the outcomes for agencies? And then, of course, any cost issues. What are the changed costs? They might be more, they might be less, but what are the changed costs involved? All of that information is currently part of a national evaluation process and will help us make a recommendation, and then for our ministers to make a decision as to whether the trial should become a permanent feature of the legislation. Slide. So what types of appeal can you make? In fact, you can make an appeal about all aspects of an education, health and care plan, except that initial decision to assess, which is the judgment, the legal statutory criteria about that decision is totally about education. It's about special educational needs and special education and the need for special educational provision. So everything else is up for the possibility of making an appeal. The decision to assess, yes, you can still appeal against a refusal to assess, but as normal, and it remains the highest area of appeals to the First-tier Tribunal. So you must have an educational complaint to go to appeal, and the tribunal does have wider powers to include or add education-only appeals to the national trial. So a family might appeal just about the education-only aspects, but in case managing that, the tribunal itself might think that there are legitimate issues under health and or social care that should be considered. So the tribunal has the power to change an education-only appeal to one under the wider remit. Slide. So I won't go through these, but these are the actual reasons for making an appeal that can go to the extended rights. So those are all decisions that local authorities make, and they are all able to be appealed to the extended, to the trial. Okay, wait, can you just go back a minute? I'll just leave it there for 1 minute so you can absorb all the possibilities. Next slide. So when there's an appeal, what do local authorities and CCGs have to do? Well, if you make an appeal, when the recommendations come back from the national trial, health must to the family and the local authority in 5 weeks to say whether they're going to follow the recommendations. If they are, then they need to just describe what they're going to do. But if they're not going to follow the recommendations, they have to explain why. So they must tell the family and the local authority, who have ultimate responsibility, why they have decided not to follow the tribunal's recommendations. If they make that decision, a family could still take the case to an ombudsman and or a judicial review on the grounds that the local authority and the CCG have not followed recommendations made by the tribunal. So let's just consider what the limitations are around the national trial. Its limitation is that you can only appeal about the health and or social care aspects if you're appealing about an educational issue. So if your concerns are simply or just solely perhaps about a health angle or a social care angle, you can't use this route. You need to follow the other complaints procedures that are outlined in the Code of Practice. A limitation is that the judgments are non-binding. They are not, they're not statutorily required to follow those. But as I've said before, because they are recommendations from a very specialist tribunal with a lot of expertise and experience, we would be expecting local authority and healthcare commissioners to follow them. And they certainly can't be rejected lightly. Okay, final slide. And ultimately, let's just remind ourselves, what are the benefits? We said at the beginning, it's never an easy decision to make an appeal. It's a long and sort of hard process to follow. So what are the benefits? Well, clearly, a major benefit is that it's now a one-stop shop. This is where everything can be resolved together. So that's a very powerful benefit. So, and it sort of aligns with the aspirations behind the reforms of creating a much more joined up system that's based on co-production, but also draws in health and social care in an equal role in terms of children and young people with special educational needs. Okay, I'm going to stop there, and I will be joining the Q&A later on. Thank you.
Thank you very much, Andre, for that really useful overview. That was brilliant. So next on our agenda, we have the session Solutions Through Mediation. So this session is going to be delivered to you today by Kids Mediation Provider, and we have the SEND Manager, Susanna Deagle, and the SEND Mediation Manager, Audrey Dorival. And we then have a Parent Carer Experience account from Lois Mansfield. So over to you.
Thank you, Holly. My name is Susanna, and I'm here with my colleague Audrey to talk about kids' special educational needs mediation, also referred to as SEND mediation. You're running ahead with the slides, Holly. Thank you very much for inviting us to give this brief presentation about the work we do. And as you can see from our slide at the top there, kids are the winners of the National SEND Mediation Award 2020. It's an achievement we are really, really proud of, and I hope it shows the dedication and commitment Audrey and I and all the people we work with have put into delivering our SEND mediation service. Kids, just to give a brief background, are a national charity. We work with children and young people with special educational needs and disability in the age range from 0 to 25, which fits well with the SEN mediation legislation. Audrey and I will take turns throughout this presentation. Next slide, please. Because this presentation will be available after the event today, we thought it was important to just have a quick reference to the acronyms that are used in our slides. Audrey and I will try and avoid using them as much as we can today, but they are there for you to refer to should need them. Next slide, please. Our aim today is to give a brief overview on how SEND mediation works, what the mediator does, how it can be used as an alternative to the tribunal, and also, importantly, because that's sometimes a big question about SEND mediation, what our outcomes and results are. I appreciate that you will want to hear far more detail about what we do, how it all works, and you can find that out on our website, but also please, at any time, contact us directly. Give us a ring, send us an email, and we will answer your questions. Next slide to Audrey, please.
Thank you, Susanna. So, first of all, we're going to talk through what exactly is SEND mediation. Well, it's a process that helps you to resolve the disagreement that you have with the local authority or health services. And most importantly, or very importantly, if you're not happy with the mediation outcome, you can still go to tribunal. So that's really important to remember. It's available to parents and carers and young people over 16 who can make a referral directly to kids. It's free of charge, and this is a myth that we would like to bust, because sometimes parents hear stories that they have to pay for mediation. Well, that's simply not true. It is free of charge, and it's confidential. It's a confidential process which is informal, it's quick, and at the end of the process, if agreements are reached, there's a written signed agreement that people can take away with them, so they know exactly what's been agreed, what's going to happen, and when. The mediation meeting is generally around 2 hours long, could be slightly more, sometimes slightly less, and it would always take place at a venue near you. Now, currently, because of the COVID restrictions, we're meeting online at the moment. So, next slide, please, Holly. So what does the mediator do? What's their role? Well, the specialist SEND mediator is there to help you prepare for the mediation meeting and to make sure that the child or young person remains at the centre of the discussions. So that's really important. I want to focus on that the young person is at the centre of the discussion, so it's a very person-centred process. The mediator is impartial. So what does that mean? It means that the mediator doesn't take sides or give opinions about who's right or wrong. They're not there as arbiter, and they certainly don't make any judgments about who's in the right and who's in the wrong. And finally, the mediator manages the meeting in a very structured way to ensure that everyone is listened to and able to give their views, so that people can really understand each other and work together to find good workable solutions. So often what I think is that mediation is a very good example of collaborative working and co-production. Next slide, please, and over to you, Susanna.
Thank you, Audrey. We can't see you, Audrey. Anyway, would be nice to see you. So what are the benefits of SEND mediation? It's supposed to resolve disagreements early and relatively quickly. So what we are trying to do is, whenever possible, we would have arranged the mediation meetings within 30 days of the family making the decision to go to mediation. It's not always possible. Sometimes holidays may interfere with that timescale, but that is the aim of what we do. Audrey has already referred to the informal setting. So the meeting will be near you when we are back to being able to have face-to-face meetings. It could be at the school, if that is what parties are happy with, at the community centre, in a library. The key thing is it's nearby. Now, there are some added benefits to mediation, and the aim of mediation is also to look at relationships that may have broken of trust in the SEND process. Part of cooperation during the meeting is to try and rebuild communication and relationships. We all know how crucial it is, because the relationship between school, the child or the young person, the family and the local authority and the health services is an ongoing one, and it's there for many years. We refer in our last point on this slide to holistic outcomes. A quick example is, say the local authority have decided not to assess your child, and the mediation meeting is about this refusal to assess. So assuming the local authority hear different aspects and decide to overturn that decision, what we then do, what our mediators do, is they look at what actions can be taken at school level or with other agencies to help the child or young person during the assessment process, which after all takes quite some time. An additional benefit, and referring back to what Andre said about the tribunal, you can go to mediation, you can request mediation about cases where it's about health or social care issues only. So mediation does not have to have the educational element. And next slide, and over to Audrey.
Thank you, Susanna. So mediation information advice. Now, you may have been told that you need to get information advice. You may have read this in a letter, statutory decision letter that you've received from the local authority and wonder, what is this? Well, you need to contact either kids or your local mediation provider within 2 months of the date of the local authority decision letter, so that you can arrange the mediation information advice session. We call it a MIAS, you might hear that acronym. And you have to do that before you go to mediation or before you make your tribunal appeal. Can you just go back one slide? Mine's gone to... Are the slides stepping ahead with us?
They are. Apologies, the slides seem to be skipping on.
Okay, I wondered if it was me.
Oh, they are moving ahead. Apologies, 1 second, let me share the screen again for you all.
Okay.
It's all been said now.
Apologies about that.
I'm just relieved it wasn't my... it wasn't my...
No.
I thought it was something I touched.
I'm not touching anything, Audrey.
No, I did wonder.
Just try that again. Okay.
I can't see the slide. Ah, there we are.
There we
Yeah.
go.
That's it.
Apologies about
Lovely.
that.
Okay.
Perfect.
Continue.
So I was just about to explain how long it would take for a mediation information session to take place. So it's about 20 minutes, and it's usually done on the phone at a time that suits you. So, you know, it's all about fitting in with family times and needs. And what the session does is it gives you information about mediation, also about tribunals, so that you can choose what's right for you. And that's really critical here. It's what's right for you, and then we'll also answer any questions that you may have. Next slide, please, Susanna.
Thank you. And just to repeat what Audrey said, sometimes there are parents that contact us and they think they have to go to mediation before they can make a tribunal appeal. That is simply not true. What you need to have is the MIAS, the Mediation Information Advice Session. And after that, you can choose which is the right way to go through your disagreement. So, under the legislation, there are two categories of access to dispute resolution. So one falls under mediation, which this slide is about, and the next one falls under what's called disagreement resolution, and which the following slide will be. So typical disagreements that go to mediation fall under the education and healthcare plan process, similar to the list that Andrew provided earlier about what can be taken as a dispute to the tribunal. So key aspects of mediation are that it is compulsory for the local authority or healthcare to attend mediation if that is what the family has requested. And the other key element is that the representative from the local authority or the health authority needs to have decision-making power. And what that means is they need to have decision-making power at the meeting up to a level where they would overturn a decision that they made earlier. Next slide, Audrey.
Thank you, Susanna. So Susanna outlined the fact that there are two areas of dispute resolution, as it were, and we've just looked at the mediation route, and you also hear people talk about disagreement resolution services, and you might wonder, well, what's that? Well, essentially it's for all other SEND related disagreements where there isn't a direct right to appeal to the tribunal, except of course placement, Part I in the plan. So it's a very broad category, disagreement resolution, and you can request this at any time, even when you've already lodged an appeal. Another important point is that disagreement resolution is voluntary for all involved in the disagreement, including the local authority or healthcare. So, for example, if you have already lodged your tribunal appeal and you think, well, actually, I'd quite like to enter into disagreement resolution with the local authority, just be mindful that the local authority doesn't have to take part in that. It's entirely voluntary. And another point to be aware of is that if there is a school-based dispute or a placement-based dispute, you can also ask for disagreement resolution around that. It's available to you. Next slide, please, Susanna.
Now, who might attend a mediation meeting or your mediation meeting? It can depend a lot on what the disagreement is. And I would like to give an example of a disagreement that is about the contents of your child or young person's final education healthcare plan. So that's what this agreement is about. What we do is we consult with the family and with the others involved who should attend the mediation. Who are the people who need to be there, who have information about the child or young person. So in a disagreement like that, in a meeting like that, you would probably have the young person, specifically if they're over the age of 16 and are able and willing to take part in their mediation. You'd typically have the parents and some supporters. So that could be a friend of the young person, a family member. It could be somebody from SEND-IAS that Andrea has referred to earlier. Typically somebody from school would be there. That might be the Special Educational Needs Coordinator, or SENCO as they're called, and then other professionals. Could be somebody from speech and language therapy or occupational therapy, people that are involved with the child. And of course, also present will be the mediator. Typically in a mediation, there will be 4 to 6 people, but it can be as little as 3. And if it's complex, then as many as 10. But as I just mentioned, the average is between 4 to 5. Yeah. Next slide, Audrey.
Thank you, Susanna. And I just wanted to recap on something that Susanna said there about the number of people that may be involved in the mediation, and go back to what I said earlier about mediation being a really good example of collaboration and co-production. So mediation, we want to give you a very brief step-by-step run through of what's involved. So if you choose to go to mediation, then we will tell the local authority that that's what you want to do. Of course, if you choose to go to tribunal, then what we will do is send you a mediator so that you can make your appeal. But if you do choose to go to mediation, then what we will do is we will make all the arrangements. That will be agree a date, a time, work with you to find out who the main participants should be. And of course, we appoint a specialist SEND mediator. Then the mediator or the service will contact everyone involved so they can get really detailed information about the case and find out who, confirm who should attend. And this is very important. The mediator will help you prepare for the meeting. So they will help tease out what the key issues are for you. What do you want to happen? Also, of course, at the centre of this is, what does the young person want to happen? And so all of that preparation is really important in terms of getting everyone in the right space and place for the mediation to take place. And the mediator manages the meeting in a very structured way. And at the end, any outcomes that are agreed are written up. And as I said before, they're circulated so people know exactly what has been agreed, when is it going to happen, and who is going to take these next steps. Next slide, please, Susanna.
So what happens at the mediation meeting? Just to reassure everybody, as we said, at the moment, our mediation meetings are virtual. And what we do is, before the joint meeting, everybody's contacted by the service or a mediator, and systems are actually checked. So everybody is comfortable and familiar with what is used for their mediation meeting. And important also that mostly before the joint meeting, the mediator will briefly have a one-to-one session with everybody in case you have any last-minute concerns or questions that you would like to discuss in confidence and not in front of everybody else. During the meeting, you can ask for breaks at any time. They are mainly used for people to consult, say, with their supporters about the solutions that have been discussed, about what decisions they might want to make, or you might want to speak with the mediator just for a private chat if there is a concern, or you might just want a break and have some fresh air if it's a long meeting. Next slide, please. The typical steps in a mediation meeting is that the mediator makes introductions and sets out the ground rules. So things about keeping notes, things about the language to be used, and people can also bring in their own ground rules if they have specific concerns. Then there are discussions so that there is clarity overall as to what the issues are, what needs to be resolved. And once everybody has gained a good understanding what those are, then parties will start and participants will start looking at options. What could be solutions? Are there other agencies that could help? What could be put in place for the child or young person? Eventually, the solutions are agreed and they are then put in the written agreement, the written outcome form. Next slide, Audrey.
Thanks, Susanna. And I just wanted to reiterate something that Susanna said there. I think Susanna has beautifully illustrated that it's a very structured process. And that's something I want people to take away from this. And we also wanted to share with you some key statistics. So most of the referrals are for refusal to assess, refusal to issue a plan, and contents of EHC plan. 75% of mediations are taking place within 30 days of us notifying the local authority that parents want to take part in mediation, and they are around 2 hours long. And over 85% of mediations result in agreements being reached. That's 85%, and 99% of agreements are stuck to. And that's really important because parents need to know that what they're agreeing to is being followed through on. And over the last 12 months, 97% of mediation participants were satisfied or highly satisfied with the service that we provide, and we evaluate after every mediation that takes place. Next slide, please. Now, what you've got on this slide deck are a number of testimonials from parents, but we're not going to go into those today. That they will be circulated to you because we are delighted that we have Lois Manfield with us today, a parent who has taken part in our mediation, and I'd like to hand over to Lois and ask Lois to share her experience of mediation. Thank you very much indeed. Thank you, Lois.
Hello, everybody. My name's Lois, and we have an autistic daughter, and she wasn't diagnosed until she was 15. So we'd struggled through the education system, not understanding what her problems were. As a consequence, she failed most of her GCSEs, and we had to try and work out what we were going to do next. And then we struggled on for another 2 years, getting her up, trying to get her GCSEs back up to date. And then she wanted to go on and do a particular type of course, which wasn't available in our county. So we worked with kids to actually try and work out what we could do to help our daughter. And the local authority, we found something that we would like to have done. And the local authority said, no, we can't afford that, go away. We got the letter saying, no, we're not going to do what you want. And therefore we went into the mediation process. And obviously we had to choose between mediation at that point and tribunal. And we felt that the mediation process was a much softer approach. It was less stressful for our daughter and also for us as well. And the other thing that we found was really good about the process is it was quick. And for us, we were right up against it because we needed to make a decision. It was July when we were trying to work out what to do for our daughter for September. And we knew the summer period meant that lots of people were on holiday, and we needed to get something to happen because with an autistic child, continuity is everything. As soon as you stop doing something, they lose ground very quickly. So we needed to make sure that there was some educational development for her going forwards. So we went to mediation with kids. It's absolutely as they've described the process. It was absolutely brilliant. The lady who we worked with, Maureen, was terrific. She was based in another part of the country and sometimes in another part of the world, but she came to the mediation session with us. We went to the local authority, and the biggest thing about mediation and when you go to the mediation meeting, is to make sure you have several plans and you've done all your background work before you go to the mediation meeting, so that you have a menu of ideas that you think might help resolve the situation. So for my daughter, we wanted one educational need for her, which the local authority had turned down. But my husband did an awful lot of legwork before we went to the mediation meeting to have plans A, B, C, D and E in the bag to try and get the local authority to understand what her needs were, and to help with the mediator who helped us work through with the local authority what options we could have. So the process, it felt really, we were quite nervous to begin with, but as the process unfolded, it became the right way to do it, because it was less confrontational. The local authority wanted to work with us rather than feeling that we were in confrontation with them, which sometimes with tribunal, we could see that might end up as a confrontational situation. And I'm interested to hear what Jason has to say about that afterwards, after I finish talking. So the process unfolded and we got a resolution at the meeting, and it was great because, again, with the local authority there, they were able to make the decision on the spot. And for my daughter, who has autism, decision making is really important, and she doesn't like long time frames for things to be decided, and it's the uncertainty with her. So for us, mediation was perfect because we came out of that meeting with a resolution, and within 5 days, and I'm not kidding, it was 5 days from the mediation meeting, my daughter was off to college in Newcastle, and we live in Cumbria. And we were able to get the local authority to support her living expenses, and then social services from Cumbria helped us with additional personal support. And in the end, for her, it was absolutely the right decision. She was 17 at the time. She's now 20. And the great news is that she's now got a place at university, and she's studying the same stuff that she did at Newcastle, but to a higher level. And without kids and without the mediation process, we think our daughter would be at home, and she wouldn't be doing what she really wanted to do, because this was about our daughter. It wasn't about what we wanted. It was about what she wanted. And that was the other thing about the kids process and mediation, is that it's totally focused on your child and what your child's needs are and what their aspirations are, because whatever their disability, whether it's physical or mental or autism or whatever it is, they've all got something to offer society. And we felt that with mediation, that allowed our daughter to feel that she could donate to society and do something really fantastic. And so I can't push it enough to all of you to use mediation, and kids particularly were just absolutely cracking. And thank you very much for the time to actually share this with you. And I'm quite happy to answer any questions that anybody has in relation to the process and how it went, and so on and so forth. Thank you very much.
Thank you so much, Lois. Thank you.
Yeah, that was fantastic to hear your account, Lois, and it's brilliant to hear you have such an incredible experience with mediation, and fantastic to know that your daughter's now at university, which is incredible. So thank you very much to Susanna, Audrey and Lois for that brilliant session. So we're going to move on now to our next session, which is on what to expect at a hearing. And we have Jason Greenwood, who is the SEND Tribunal Operations Manager at HMCTS, delivering this session for you today. So take it away, Jason.
Thanks, Holly. And thank you very much for allowing us to talk a little bit this morning around actually what to expect at a tribunal hearing. You've probably seen me or my name on stuff for the tribunal. A bit of background about me. I've worked for SEND for 18 years now. Started off as a clerk, or moved through the management into looking at leading the service at the moment. So sort of like a real privilege to be in that position to help children and young people come through the process. So I've got that huge wealth of experience, and also the team in Darlington. The team is in Darlington, and they do the whole of the country. The team were awarded last week HMCTS award nationally for the work that the tribunal have done throughout the COVID period as well. Some of you might have been in the process where we were having to cancel hearings, and since March the 17th we've not cancelled a hearing as yet. So fingers crossed that continues, and I'm touching wood and all that sort of stuff as well. So lots of work to be done. So I'm going to be sound like Professor Chris Whitty and say next slide, please, at a government briefing. So we'll go on to what this session will cover. So we've got to look at actually what to consider before a hearing, what to expect when you arrive at your tribunal hearing, who you'll meet, and also how a typical hearing runs, including virtual hearings. So SEND is one of the leading tribunals that have continued to hear appeals throughout COVID-19. We did quite a huge lot of work, working late nights to actually get covered and switching from hearing centres to the digital world. So SEND in HMCTS terms, we haven't cancelled any hearings due to COVID, and we've continued to work with children, young people, parents, reps, etc., to continue with getting that justice for children and young people at a time that's needed. So next slide, please. So the purpose of an appeal hearing is the SEND Tribunal is responsible for handling appeals against local authority decisions regarding special educational needs for children and young people as well. So our age range is from 0 to 25. Prior to the Children and Families Act, we were only looking at 5 to 16, and the Children and Families Act came in and extended that to 0 to 25. So we now have that jurisdiction over that. So we are independent of local authorities, schools, and the judiciary as well. We are totally independent. We answer to ministers and also the local government ombudsman. So if there is any administration complaint about the service that we provide, that is through the LGO. So the focus of the tribunal is on the needs of the child or the young person. So what we do is actually we want to hear about the child or the young person, and actually parents are the best placed to talk about the child or the young person at a hearing, because you're living and spending that time with your child, young person. So actually coming to tribunal, the tribunal is aimed at actually not being very legalistic, and actually it was set up 20 odd years ago for anyone to come to the tribunal that doesn't have legal experience, for you just to come along and say what your child person is struggling with. So at the hearing itself, the tribunal will assess the evidence, and that's in the written format as well. We have some deadlines throughout the process for responses to be able to have an effective hearing, because we want to be able to have everything, and at the end of that hearing we'll make a decision and send that out. So we don't like adjourning cases, because that puts delay on it, and we are aware that actually at the beginning of the process, before it comes to the tribunal, there's already a lot of time there. So we want to hear the appeal as soon as we can. At the moment, we're registering cases around 15 weeks. I know that's fluctuated quite a bit. We were registered at 12 weeks, 14 weeks. It got pushed to 20 weeks through COVID, but we've managed to pull that back now. So it's around 15 weeks from registering your appeal to getting a hearing date. And we're doing some work around actually how we look at hearing dates in the new year. That actually we're looking at a new system. Actually, instead of us saying your hearing's got to be on the 24th of February 2020 or 2021, actually we're looking at actually trialing somewhere where we say, can you agree a date with the local authority in a certain time frame, and you'll get to choose a date agreeable with the local authority as well. And we'll be looking at that feedback, because it's 50-50 around actually people like that date being set up front. However, some people are saying, oh, witnesses, etc., 14, 15 weeks out can be a bit difficult to book. So we will evaluate that. So at the hearing itself, we'll listen to the accounts and explanations from the witnesses. You may have teachers there, you might have your educational psychologist, your SALT, doctors from or medics in the hearing to say actually what the child is good and struggles at, and what they need more help with. And the tribunal is an inquisitorial tribunal, so it will ask questions. And we say that the parent, young person, are the best people to talk to us about that, because as I say, that we are living with those children and young people with those special needs as well. So parents are really a great key for those hearings, and also hear the views of the child or the young person. So we love to hear from the child or young person to say, actually, what are you struggling with? What do you need more help with? What are your views? And we do that in a sense that we have a little start at the start of the hearing where you've got maybe 10 minutes with the child and the young person. We don't have everyone in the room at the same time. We want to try and make it as informal as possible for the child or the young person, because it can be stressful, especially if you're coming through the Royal Courts of Justice front door and you've got the media all around you. It can be a challenge to get over that courtroom door. And probably like me, you've never had to step foot in a court before. It's and instantly you go at the court and you're like, really tight up. Sometimes I feel that when I have to queue into some of the courts. I don't get a fast pass into the courts either, so I have to stand in a queue to get frisked and all that. So we do that informally. Normally it's just with the panel and the parents, the rep and the local authority rep. So we're not having everyone in the room at the same time. Are quite simple for the child, young person, depending on what their need is. And what type of appeal it is, because the panel want to listen to what the child's view is as well, and that is important for the appeal. So we'll go on to the next slide, please. So what to consider before your hearing. So we do send out attendance forms. That's to find out actually when we're outside of COVID, we would normally be in a hearing room that actually you would be attending a courtroom. So some of our courtrooms are quite spacious, some aren't, and some we have to do some rejigging with furniture and all sorts of things. As the tribunal was set up, it was an informal tribunal, and it still is informal. We're not swearing anyone in, no one's on oath, etc. And when I was out there clerking, what we had was we have a conference room table, and the panel sit at one side and all the parties sit at the other. It does feel like a bit of an interview, but it is more informal for us. So yeah, there may be some limitations with people coming to the hearing. So we do say three witnesses for each side. So parents have 3 witnesses, local authority has 3 witnesses. You don't have to bring 3, but it is useful to think about actually who knows the child, who's dealt with the child or young person, and what's the best evidence that they can give the panel to make a great decision. So that's the hearing as such. If it's virtual, exactly the same rules are. It's three witnesses for a local authority, 3 witnesses for a parent, young person to bring along. We do that so we don't have lots of people in the room, and the hearing taking 3, 4, 5 days, etc. everything that's in the bundle. So you might have your expert witness reports that I can't get to the hearing, but they can provide those in the bundle. That bundle is going to be read by the tribunal panel, and so that witness might not necessarily need to come along if you've got that already in the bundle. You will have breaks throughout the day. If you're going to a hearing at a centre, that suggest bringing some food with you, but maybe drinks. Yes, our venues don't have canteens. Well, most of them don't. Some of them do. But yeah, if you bring along some food, there is different types of hearing length. So if you've got your refusal to assess case, your refusal to make an EHC plan, etc. They're on your half-day hearings, but the national trial mainly a full-day hearing. So do plan to have a full day. All of our hearings start at 10 o'clock. For all-day hearing. If it's a half day, it's either 10 o'clock or 2 o'clock. We say all of our hearings at the moment are virtual. We've had a hybrid hearing, and we are allowing hybrid hearings where is needed. So if parents, young person, don't have the technical ability to beam in to a hearing, we can bring you to a hearing centre, and we'll have a screen with you and whoever else in the room, and other people will be virtual. So we're looking at hybrid hearings as well. We do say please be addressed appropriately. I've seen hearings take place on a bed, etc. And we just say actually look around, look at your surroundings as well. It is still a tribunal hearing that you're taking part in. So yeah, you might have something behind you that maybe I don't know, a calendar of such Kylie Minogue, and maybe someone doesn't like Kylie Minogue. So just have a look, see what's behind you. I tend to have a roof in my view. If your hearing is virtual, there is a message that comes up on the screen. You're not allowed to record the hearing. It is a criminal offence to do so. We've had a couple of screenshots on Twitter, and they're being took down quite quickly by Ministry of Justice. So just a reminder that actually you can't record. The tribunal don't take any recordings of the hearing other than the decision that comes out at the end of the hearing. That's the and our decisions in the Special Educational Needs Tribunal are full decisions. You might get a decision of 15, 16 pages, because that actually gives you the reasons for the decision as well, and why the panel have come to that decision. So we'll go on to the next slide, please. So what to expect when you arrive at your tribunal hearing. I don't know if you've seen the video. I did a DVD of how coming to a tribunal. This was probably about 10 years ago. I probably look about 5 stone heavier now than that. And got some grey hairs as well. So if not, that's still available on YouTube. It's still quite relevant of how it's set out, how the questions are asked from the judge and the parties. So you can go on there and have a look. And as I said, through COVID, we have these hearings virtual. So they are virtual. We send out a link for you to log in. If you wanted a hybrid hearing, we can get to hold a hearing near a centre near you. And outside of COVID, someone just posted in into the chat the video. That's not me, unfortunately. That was our previous Deputy Chair President. Normally, you've got 2 hours travelling between your home postcode and the venue. I know that sounds quite daunting of 2 hours, especially if you live up north, where you've got Darlington to Cumbria. That's around 2 hours, and if you know the area, that's quite a bit of a drive or on the train. So we do look at that. It is 2 hours from the parent's home. If that causes a problem, write into us. We will look at actually seeing if there's a local venue near you. We also had got other options of hotels. We've heard appeals in church halls, etc. All regarding risk assessments we need to do before a hearing. But majority of the hearings take place in our court buildings. As you know, HMCTS and we've gone through some budgetary constraints. So hotels are very, very rare unless it's sort of like we can't find anywhere else. So that's where we do. In a courtroom, you might be in a informal courtroom. That's our aim, is to get an informal courtroom. But however, sometimes it may be in a formal courtroom. We don't like putting parents, young people in a formal courtroom. We will rejig the furniture around if that's the case. In Darlington, our courtrooms have got docks in where you can send people down into the police station to be arrested. However, we don't use that part of the court. We walk past that and then use the front of the court. So we do look at how the court is running, and we won't be saying anyone to be sat in a dock, etc. When you come into the court, you'll be welcomed by a tribunal clerk or usher. Some venues, it might be a security guard, and they'll make sure that you feel comfortable and at ease. So normally it's a welcome. Who else is joining you today? Be the go-to person between you and the panel to say, actually, everyone's here, everyone's ready. Any late evidence that you may have that you want to submit to the panel, give to the clerk. The clerk will pass that up to the panel to hear and to read that. So yeah, and if you'd like your child to attend the hearing, you'll need to put this in writing in advance of the hearing. It's just on the attendance form. I think there's a tick box to say, is your child appealing or not? Yes or no. It doesn't need to be anything major. And also just a reminder that you'll have to have someone to look after them while you're not in the hearing. I did a hearing maybe 13, 14 years ago, and I had to sit with a child in the hearing and play with toys. And we're not paid to do that. We're not insured to do that. So please be reminded you need someone to look after them, or actually ask grandma, granddad, etc. to take them back home or take them to school. That's also a possibility. Next slide, please. So who you'll meet on the day, you'll meet the tribunal clerk or usher, the specialist member, and these are experts and chosen from experts in the field of SEN, usually from backgrounds of educational psychologists, SALTs, so speech and language therapist, head teachers. We've got a couple of ex-local authority people on our panels now, and also you've got the SEND tribunal judge. So in a national trial, you've got two specialist members. One has got experience with health and social care, the other with a special educational needs background, and the tribunal judge who knows the law. And there could be a tribunal judge or a member as an observer as well for the training purposes. So we are recruiting more judges and members into the tribunal, and at the moment we're seeing some observers of our judicial colleagues coming in to observe how a hearing runs for their training purposes. Next slide, please. So while you wait for your hearing, the tribunal panel will be busy identifying the main issues to cover and deciding what questions they want to ask through the hearing. So normally when you're outside, the panel will meet 9:15, 9:30 before the hearing, discussion around actually what they've read in the bundle. So the paperwork that you've submitted in advance. When you come into the hearing room, it is informal. You'll have your name plaques set out on the table with some water or bottled water in the COVID situation, or on video. They'll ask you to they'll introduce themselves to say who they are on the panel and go through that. They'll explain the procedure, how it's going to work throughout the day, and also explain around the decision-making process. So the decision won't be made on the day. You'll get a full written decision within 10 days of that hearing to have, and that'll come out at the same time as going to both young person parents and the local authority. The tribunal will raise issues they deem as most relevant, but you're also able to raise any other issues that you may feel relevant that the tribunal may not cover. So yes, and parent will always have that final opportunity to summarise, same with the local authority as well. The hearing is very informal. Next slide, please. So it is an informal setting. We try one person can speak at a time, about one topic at a time. Everyone has equal time to speak in the hearing, and the judge will decide when to take breaks, but you're able to ask for a break if you need that. Parents can question witnesses on the topics being discussed. So if you don't agree with the experts saying, oh, actually, this and this, you could say, actually, that's wrong. This is how child or young person and deal with. So, is it informal? Court, a tribunal that we operate in, and yeah, you might need to have a break. You might need to speak to your representative outside the hearing. You might need to go to the toilet. We all need to do that. So yes, there we go. Next slide, please. And I know that I've overrun by about 2 minutes now. So more information can be found at all these websites. So you've got the what we do with the First-tier Tribunal, the guide on how to appeal a SEND decision, including an easy read version. So there's a lovely version that's been written for us. The forms can be found. There's a long link there, but we've shortened some of our links. So if you use the tribunal, we use tinyurl.com, and then we put /send forms instead of having to type all that out. You can find out more about the HMCTS telephone and video hearings during COVID, the YouTube series as well that features me. You'll see a younger version of me, and also one that has just been published today is the HMCTS annual report. That's now online. So if you want to find out about actually how many appeals we've had in the system last year in school years, that's now published online. Also previous years are there as well. So that's very interesting to find out a bit more about actually how many appeals are being heard, what type of appeals are being heard as well, and what the outcomes are as well. And you can also find us and get us on our email address, send@justice.gov.uk, or phone the helpline there, and they'll help. The helpline's open from 9 till 5 every day, and that's the team in Darlington assisting anyone who needs any procedural advice. We can't give you any legal advice because we're just administrative staff. We can't tell you what to submit, who to bring to a hearing, etc. We can say these are the types of people. So we would say you would need to either seek legal advice or go to those parent supporters, etc. out there. And there's more information on our website around parent support and free support out there as well. So that ends my session. Sorry, I've overrun by 3 minutes, and I'm happy to answer any questions at the end of the webinar as well. Thank you.
Thank you very much for that, Jason. That was really, really informative. So thank you again to all of our presenters. We're now going to move on to the panel Q&A session, which is going to be hosted by my colleague Emma. But just quickly before we do, I'm going to post a link shortly to a quick feedback form, and we'll be really grateful if you could fill that out about your experience on the webinar today. That would be really helpful. So I'll pass over to you, Emma.
Thank you, and thanks to all the speakers. Some really, really interesting information today, and I hope it's been useful to everybody who's joined us today. I've been chatting to some of you as the sessions have gone on, and I've collected some questions from you. If you have more questions that you're thinking of now, please feel free to drop them into the chat and I'll work my way through them. If we don't get a chance to cover everybody's questions today, I will still be collecting them, and I will endeavour to speak with the presenters after the webinar, and we'll include answers in our follow-up email, which we hope to send out next week once we've uploaded the recorded webinar to the online toolkit. So I'm going to start with a question from Simon, which I think probably best answered by Andre. He would like to know whether or not when are the tribunal able to order that the local authority conduct assessments when these haven't been done by the local authority?
In general terms, if the local authority hasn't undertaken the statutory assessments that are required for the initial assessment, then that could be ordered. If there are requests for other supplementary assessments that are more specific, then that will be down to every individual case. So that will be a decision made on the merits of the individual presenting evidence.
Fantastic, thanks, Andre. I've got a few on mediation, so I'll try and cover them all in one go. So these are for Audrey and Susanna. So we have a question regarding local authorities who are attending mediation sessions, and whether or not, or when they don't have the decision-making powers to be able to come to an agreement in a session. I think this is probably something that some parents have experienced. Do you have any advice on how a parent should manage that?
Yeah, Audrey, shall I take this one?
You can, and I'll come in on that afterwards.
If I say a wrong thing. Right. So obviously, I can only speak here for the kids process, but it is right what you're saying, Emma, that parents are quite often concerned before they opt for mediation whether the local authority will send somebody with decision-making power. That does happen in certain local authorities more than in others. So what we do is we have a pre-mediation agreement form, and which all the participants and parties have to fill in and have back to us before we arrange a joint meeting. And that includes the question from everybody whether they have decision-making power. So the local authority needs to tick that. If they don't, we will get in touch with them and follow up and explain that for mediation, they have to send somebody with the delegated power. There are some very few exceptions to that for which kids have issued guidance. And we would then be very openly discuss that with parents and say, for example, the local authority will be happy to discuss B and F and other parts of the plan, but they may have a problem making a decision about part I. So that's your placement. So if that is the case, we would go back to parents and say, there may be limited decision-making power. Do you still want to go ahead with your mediation or not? So it's in the open and everybody can make a decision. Audrey, did you want to add to that?
Just to say, I mean, Susanna, you've answered that comprehensively. Just to say that so that parents know, it's in the regulations at regulation 37.1 of the SEND regulations that the local authority must, and it's not a may or should, it's a must, send someone with decision-making authority on the mediation issues. So that's what I wanted to add.
Could I also quickly add, because I think the question was, did they have the authority to say for it to go back to panel? And the answer, no, that would not be decision-making power, because that's just a decision that's been postponed rather than a decision being made. So we will make sure that there is clarity about what it means to have decision-making power.
Yeah, it's about parents. It's about parents knowing that if they're going to invest their time in a mediation, they know what the the potential limitations are before they even think about entering that space and that room, and that's fundamental. Everyone needs to know what they're signing up for.
Yeah, thank you. And there's just a follow-up question that just popped up in the chat. Siobhan's asked, is that on that same point, is that the same in regards to disagreement resolution services?
Yes, that would be the same. That would be the same. That want people to have decision-making authority for it to be a worthwhile exercise.
Thank you. A question from Michelle. You might have picked this up, covered this already in your presentation, but just because I think it's a useful point to cover. Michelle's asked whether a parent can have a lawyer present at a mediation as an advocate.
Yeah, a very interesting question, actually, because some of you may be aware that of recent case law, the Kumar versus Hillingdon case that came out. I think the judgment was released this week, and the judge was unequivocal in making clear that a parent can bring, I think they could put a number on it, actually, one lawyer to a mediation. So I think that's the very short, simple answer to that.
Fantastic. Another one which I think is quite a useful point to clarify on. Simon asks, can there be past agreement from a mediation meeting, or is it an all or nothing?
Susanna, do you want to take that?
Yeah. We obviously, well, parties, not we as mediators, but parties will aim to reach full agreements, but there can be partial agreements. For example, if it's about the contents of a final plan, certain aspects might be agreed, but others not. So really important here, the reminder that if for a family the outcome of their mediation is not what they had hoped for, then after the mediation meeting you get issued with the what's called the Part 2 certificate, and which then again allows you access to tribunal. Sometimes partial agreements can be really useful because they might clear out certain issues, come to actions agreed on certain elements, and then just leaving some outstanding. I would say that when looking at, again, referring to kids, when we look at our statistics about percentages of full and partial agreements, I would say well over 50% are full agreements. And then there are some that are partial agreements. I would have to look at it in more detail. Audrey, have you got?
Just to re-emphasise the usefulness of the partial agreement, it's not something to be sniffed at, because if it can narrow the scope of what's between people, that makes it much easier if there's then just a very small matter to go on to tribunal.
Thank you both. I think the attendees were very interested and welcomed the stats that you provided on outcomes for mediation. I know this was picked up by Andre, but just to follow up on that in case people haven't had or can't see the chat, is there any national statistics available on mediation and or disagreement resolution? I don't know if Kids wants to pick that up, or if Andre wanted to pick that up.
I think Andre might pick that one up better in terms of the national picture.
Yes, in terms of mediation, we've been publishing national data, and it's broken down by individual local areas for about 3 or 4 years, but that data is available. So if you want to look at it for an individual authority or for a region, or just get the national picture, then you can do that. And there are two real interesting columns. One is the total number of mediations for each of those areas, so for nationally, local authority and regionally. And then from that, of that total number of mediations, what percent went on to a formal tribunal hearing? So that two data, so you can get the figures for that. The second question was about disagreement resolution. There is no data collected nationally on that. Some individual local areas may have it at their fingertips, others may not.
Is it possible for that a link to that data to be circulated, Holly?
So I was just going to say, actually, we'll add that to the email and the follow-up.
Yeah.
Fantastic, thank you both. So just one last question for mediation. I'm going to read this out because I want to make sure that I'm asking it correctly. One of our attendees has asked, they had an EHC plan issued recently, but the decision letter means they need a certificate by 26th of December, which is obviously quite clashes with Christmas. She and the LA are waiting on medical reports, so she'd like to know, is mediation the best route to buy more time to sort out the EHC plan, given the delays in the reports, or go straight to appeal with a mediation certificate? That's quite a long question.
I think if I can start that one off, Susanna, you can come in on that one.
It's an interesting question.
It is an interesting question, and I think, and Susanna might have a different view to me, we don't see mediation as a process for extending time. I'm aware that in practical terms it could be used as that, but that's not how we would see it. So I think what I would do is throw that question back really and say, well, you need to think about what sort of timelines you need to work within and how quickly you need to get matters on, how quickly perhaps you need to get the matter registered for appeal and so forth. But we wouldn't be suggesting that mediation was a process for extending time.
Yeah, we have an interesting situation where both we and the LA have agreed that the EHCP is not fit as it stands. We've got they've issued it because they had to meet the deadlines because of COVID and everything. Then the deadlines came back in, so they issued the EHCP knowing it wasn't right. And we've been waiting for other medical reports to come in. And against this, I'm worried about the fact that I might miss tribunal. So do I just go straight for tribunal in that situation?
Susanna, any thoughts on that one?
Is it Andrea?
Yes.
Yeah, I can just about read it there. Andrea, hello, Andrea.
Hi.
Thank you for the question. When you say you have your timing is the 26th of December, have you had your mediation information advice session? Have you had that?
No, because we were waiting for the 2 months and then asking at the end of the 2 months for a mediation certificate. That's what we were going to go for.
Right.
Because it was the EHC plan was issued on the 26th of October.
Right. I think the first step is to arrange your MIAS, because that opens then your option to either go to mediation or to go to the tribunal. So it's really important to get that sorted, so that you do that as quickly as possible within your 2 months. Your 26th from October. The MIAS then should, sorry, I'm just gonna have to not plug myself in, plug my laptop in. Sorry about this, Andrea. So once you've had that, so then you see that certificate you get through the mediation information advice session gives you then again time to lodge your appeal or to opt for mediation. And we as MIAS advisors in that role, we cannot say, we have to be impartial. We can't say, mediation is better for your case or tribunal is better. That's for you to decide, and maybe in consultation with your SEND-IAS, if you have been in touch with them, they will be really good. And if you've also maybe had a look at your local offer and see what other advice there might be available for you. But having had the MIAS gives you then the time to make that decision what to do. So I agree with what Audrey said. I wouldn't say, because I don't know you, I don't know your family, your specific situation. We would always say mediation is a good thing, because if it doesn't work, you can still go to tribunal. But that's a slightly biased view, of course, from our perspective. And I wouldn't want to give that to you today.
And I just add to
Has that been helpful at all?
It is. I mean, I was chatting, actually, Senna called me this morning and they're saying, look, we're trying to get forward with this, but until we've got medical reports, they're as stuck as we are. And so they've been caught by the deadlines, I think, and we've been caught by the deadlines, and
Yeah.
it then becomes a tricky situation because we all know that the HCP cannot possibly be final, but they've had to finalise it.
Yes.
And
Yes.
so everyone's sort of caught.
Yes.
Trying to work out as a parent what's best for us, that we make sure that should my local authority not come up with the goods, I'm not then going to miss out on that opportunity to say, excuse me, this isn't finished.
I mean, the only thing I would add to that, Andrea, is that if you were to opt for mediation, for example, you were to get your information about mediation and opt for it, you can withdraw from that process at any point.
Yes.
So I think that's, you know,
Okay.
you've always got your options. That's the main thing. But what you don't want to do, and Susanna has alluded to this, is you don't want to find that you are out of time.
Exactly.
And then you lose even the option to get a mediation.
And that's what I was worried about.
And so that date of whatever it was, 26th of December, whatever it was, you know, that's a critical date, and you must act before that date.
Brilliant.
So to jump in here, guys, we're actually coming to we've actually come to the end of our time, so I'm conscious that people are going to be leaving shortly. So I'm sorry to cut you off, but Andrew, maybe I can put you in contact with somebody so you can have a follow-up chat. Because I don't want to. I want to make sure you've got the answers to your questions that you need. So if you want to drop me an email, I can put you in contact so you can finish that conversation. I do
just quickly add, Emma, though, to that call with Andrea. It's a good job that the LA did issue the plan, even though they knew it wasn't right, because at least then she has a right to appeal. If they hadn't done so, she would be stuck in this sort of ether of not being able to do anything. And whilst it's frustrating, you know, fair play to the local authority for issuing something that they knew wasn't right, were honest and open about it not being right, but at least Andrea and her family have got the right to appeal it.
Thanks, Tina. That's really useful. And I'm sorry we haven't had a chance to get around to everyone's questions. I have taken a record of the questions that we haven't managed to. So I will arrange and make sure that we've got answers for those who have asked, and I will include those in the follow-up email that we'll send out early next week. But thank you so much to all of our speakers. Thank you for all attending. I hope you found it useful. As Holly mentioned, we'd love it if you'd be able to share feedback, fill out our feedback form. So it all helps us understand what you would like to know and what you find helpful, so that we can make sure that we're providing with the most useful resources and most useful sessions like this. So thank you very much for joining us.
Thanks, everyone.
Thank you.
Thank you.